Hello, today we're going to continue a discussion of the Soldiers and Sailors Civil Relief Act. And in contrast to earlier discussions about what the act means and some of the protections it provides for service members, we're going to talk today a little bit about what a civilian spouse can do when faced with a request for a stay under the SCRA. So the first thing to consider is all is not lost. It is not, a request for a stay is not an absolute mandate. There are some mechanisms that you can use to ensure that the case proceeds timely and some necessary issues are heard. The first thing to consider is, if you recall from earlier blogs, the service member cannot simply say that I am in the military and therefore I am entitled to a stay. The service member has to indicate that there is something about his or her duties that require a stay. So for example, when faced with one of these requests, the attorney should inquire with the client and perhaps the military, what is the service member's station? What are their orders? Where are they? If the service member has a desk job in Madison, in all likelihood, there's nothing that's preventing them from participating in some way. Obviously, if the member is stationed overseas or in a combat zone, that's a different story, but don't simply accept the fact that there is a request for a stay as a fait accompli. Look into it and see perhaps if there is a legitimate reason for the request. Second thing to consider is, are there any issues that really are not in dispute? In some instances in Wisconsin, a divorce can actually be granted before some issues are resolved. So for example, if a divorce can be granted before custody of children is finally resolved. It's somewhat rare, but there can be good instances, usually financial, to perhaps save a spouse from once the other incurring substantial debt, etc. Perhaps the service member will simply agree to the divorce with certain issues to be resolved upon his or her return. There may not be a dispute about who will have custody of the children. If the member is stationed in a combat zone and perhaps won't be back for some time into the U.S., there may be an agreement that the child will be primarily placed with one parent, the non-military parent, and that parent can have a certain amount of custody, sole or joint, some type of custody pending the service member's return. So again, a stay means that there is not necessarily court action, there's not court hearings. It doesn't mean that the case can proceed through some type of negotiating privately with lawyers and clients. And again, if there are no disputed issues, the case can proceed through agreement. The next thing to consider is just because, again, there is no court action during the stay does not mean that there can't be some information gathering. So there potentially, if the service member has some ability to respond to requests, a formal or informal request for discovery, for example, the member's leave statement, their points or time served in the military statements can indicate their income and various circumstances surrounding their service. While the case waits for the service member to return from duty, there can be certain things done to perhaps value a retirement plan, determine the service member's income, etc. And that information can be obtained in most circumstances, except maybe the most extreme, from the service member. It shouldn't take too long to either sign an authorization to allow counsel to obtain that information, or perhaps the service member can just ask a commanding officer to provide it somehow, or some branch of the military, in essence, military human resources, DFAS or something of that nature. Also, there, at least in Wisconsin, many hearings, some limited hearings, are held by offers of proof, which in essence is the lawyers doing the talking and stating like, well, if my client was here, this is what he would testify or she would testify. And if there is a somewhat immediate need for a temporary hearing to address perhaps financial issues or something of that nature, maybe something simple like child support, if the member is overseas and can't participate, but the member has a lawyer and both sides have the member's earnings statement indicating what the income is, it is possible that as long as the member has some ability to communicate with his or her lawyer, that something like a temporary order hearing or a limited child support hearing could be heard, maybe with everyone's agreement, by these offers of proof. There is a mechanism in case some mistake is made or the member doesn't feel comfortable with the outcome. There is a mechanism to request a rehearing of these type hearings before a judge. Usually they're heard before a court commissioner. But there is a mechanism for the member to do that if things don't go well. Again, a request for stay may allow the parties to handle some limited issues through these sort of this offer of proof process. It may require agreement, but again, if there is agreement to proceed on certain things, that is possible. A stay, even if granted, can be changed with the agreement of both sides. So again, if you are the member and you are requesting a stay, the takeaway from all this is, in your request, make sure that you provide some specifics as to why you are not available, instead of simply a blanket statement that I am in the military and request a stay. If you are the non-military spouse, don't simply accept the request if there is a good reason to dispute it. At least look into it, and there are some things that can be done, as we discussed, that can allow the case to move forward, even if it's just something like gathering information, etc. So upon the member's return, the case is somewhat further along than it otherwise might have been, and you're not starting from scratch.